We'll get started with some introductions and we'll let people kind of pool in as we do that. I was just talking to Steve and Ariel, and they're both from the humility school, they say, and would prefer they didn't talk a ton about themselves, but they're both very esteemed in their respective professions. Steve Lockshin is the co-founder of Vanilla, where I'm also from. Vanilla is an estate planning platform for financial advisories. He's also the co-founder of Advice Period, where Ariel is also a wealth advisor. And Advice Period has a bit of a non-traditional, I would say, approach to wealth management, which Steve will get into a little bit later. And Ariel is a senior wealth advisor and strategist with Advice Period, but not only is she an advisor, she's a former attorney. So she worked for many years as an attorney in some white shoe firms, then came over into the RIA world, and then also eventually came to Advice Period. So they both bring a lot of great perspective here for both financial advising, legal as well as technology. So I'm very excited to have them here today. I'm Dan Broccoli. I run content over at Vanilla, where we're doing our very best to educate financial advisors about estate planning and make it simpler for all of you to do estate planning. Steve and Ariel, do you have anything you'd like to add to your intros? Maybe Steve, if you want to talk about Ariel, and Ariel, if you want to talk about Steve.
I was
know
just
you
going
like
to
to be
weigh in
humble.
on Ariel. I'd say, she is still an attorney, so albeit not practicing. She's a recovering attorney, but no, it's been great to have her on our team. She's taken what I think was already a high level of intellect around tax and estate and helped us notch it up a bit.
And I'll introduce Steve a little
You
bit.
can say great things about me now.
Steve said that he's not a lawyer, but he just plays one on TV. And I'd say he's the best played lawyer on TV. He knows the ins and outs of estate planning, comes at it from a totally different direction. And, I think it's been great working together with him and actually learning a lot from him in my own field.
Terrific. Well, let me set up a little bit about what we're going to talk about today. We're here to talk about the estate planning playbook. I'm going to drop a link in the chat. If you haven't downloaded the playbook, I encourage you to do so. It's a terrific resource. We're going to kind of go through some of the nuts and bolts today, but there's going to be more in that playbook that we won't get to. So you should definitely download that for yourself. And we're going to talk about, some of the specifics in the playbook, but also kind of an approach to estate planning and specifically an approach for financial advisors and sort of the role of financial advisors in estate planning, the role of attorneys, how they can work together, fees. We're going to kind of go through a whole lot of different things here today. Why don't we start with, if you don't mind, and by the way, folks, we're going to keep this very conversational. And please do feel free to drop questions in as we go. I'll try to get to them as we go along. If I don't get to them as we go along, we're going to have a good 15 minutes at least at the end to go through Q&A, because I think that a lot of you out there have questions. There's a good group here today, so I want to make sure we get to those. But why don't we start with a little bit more context, if you wouldn't mind, Steve and Ariel, about Advice Period, because as I mentioned, Advice Period works a little bit differently. So I'd love to hear both of your perspectives on, how you approach wealth advising and how it's a little bit different.
Yeah, maybe I'll start. Advice Period really was a concept that kind of memorialized our thought process around wealth management. So over the past 15 years, let's say, and I've been in the business for 30 plus years, we started to feel, particularly with the clientele that we were serving, that estate planning really was the big impact item that we could focus on for clients. And most of our clients were folks that were over the exemption limit. And we de-emphasized, and when I say de-emphasize, it doesn't mean it's important, the more commoditized service of investments. So, you can go from firm to firm to firm. And when I give speeches at industry conferences, I'll often say, how many people in the room think they're smarter than the person next to them? And inevitably, one or two people raise their hand. But for the most part, they all agree over a long period of time, they're going to be pretty close when it comes to client results. And so by definition, it is somewhat commoditized. I don't want to undervalue the work that advisors put into handling clients, coming up with the information, manifesting the transactions that need to occur, and all the money movements and things of that nature. But it seemed that estate planning was very much an underserved skill that advisors were not delivering to clients, and we wanted to focus on that. And so the firm kind of turned things upside down, where the typical advisor comes in with investments and talks about maybe taxes and maybe estate planning, and we'll talk later about what that means from firm to firm. We were coming in directly talking about estate and tax planning, and then would talk about investments, because that was more of the sideshow and estate planning was the main event, when I think the rest of the world is typically upside down. And Ariel can probably add, because she came, she'll tell her own background, but she came out of practicing law into another investment advisory shop I'd say is more traditional. So maybe Ariel, spend a minute on your experience doing that.
Yeah, sure. So I practiced for about 8 years in big law firms in Manhattan, focusing on trust and estate planning for ultra high net worth clients. And then I made my way in-house to another investment advisory firm before I jumped over to Advice Period. So I've seen a little bit of the inner workings of other financial, or at least one other financial institution, and I've observed how other financial institutions work. And I agree with Steve. The focus for what I've seen is the investments, and the estate planning is a side dish, the entree. It's something that is, considered after the fact, as maybe a value add, as something that is not necessarily an afterthought, but not necessarily the focus of the conversation. And because of that, at least from what I've seen, it sends a message to the client, right? That the investments are the focus, and the importance isn't necessarily on the estate planning, because it comes after the investments. And by contrast, at Advice Period, we're sending a clear message to the client that this is the entree, this is the important thing. And as a result, the client also values it as one of the more important aspects of the planning. And with the client, also seeing the importance, you have the client buy-in, client interested, and you become more productive in getting things done for the client that they want to accomplish. So I think it works really well at Advice Period, and we accomplish a lot for our clients in that way.
And by the way, if it's not obvious that Ariel's a foodie and she talked about entrees and side dishes, and I'm a clown, I talked about the sideshow event. So there's some differences.
Telling metaphors there. I love it. Talk a little bit, if you could sort of quantify the value here. So you flip the approach on its head and put estate planning at the center. For ultra high net worth clients, why? Like, you've talked about the commoditization of investments, but talk about the value of estate planning a little bit.
I will, and remind me, because when we talk about what people focus on, we should spend a minute and go back and talk about how folks are compensated, because it's very telling about how firms think about this stuff.
Right.
But in the interim, the typical approach, let's say, that an advisor might take that is more investment focused is, let me see what investments you have today, and I'll come up with a strategy and I'll analyze your investments. And unfortunately, the pitch often is, I can get you into a better asset allocation, or I can get you access to managers or funds you might not otherwise get access to. I may have a focus on alternatives, or I may have a tax focus and use PPLI, whatever it is. They'll usually have a hook that says, this is why I'm different than everybody else. But very often they're just different flavors of vanilla, so to speak. Whereas we'll typically come at it from a very different approach and ask the clients, what's your total net worth, and what's in your estate or out of your estate? And so let's say a client says, my total net worth is $100 million, just to keep math simple for someone like me. And let's just assume, they have no exemption left, again, to keep math simple. So I ask them their age and how long they plan to be on this earth. And if you use rule of 72, money at 5% doubles roughly every 15 years. So you can run some simple math. And if they plan to be here for 45 more years, 100 turns to 200, 200 turns to 400, 400 turns to 800, and you can take 40% of that number, and that's a really, really big tax number. And our job, when we talk about estate planning, is to get that $320 million number down to zero or close to zero, but significantly reduce it. And the nice thing about focusing on estate planning first is there's no increase to portfolio risk. You're just moving pieces around. There's an immediate and tangible return. And it's 40%. And how long does it take to make 40% after tax in a portfolio? And then the bonus is on top of that, every year that you pay taxes out of the grantor trust, it's like another tax-free gift into the trust. And all the compounding of the growth is like another tax-free gift into the trust. And so it becomes impossible for an advisor that focuses only on investments to ever keep up with an advisor that does nothing but focus on, let's call it index investing, but understands estate planning, because the estate planning benefits are so big. And so we'll come in with that approach and then say, and by the way, we can also handle your investments, because part of estate planning, as I said, is moving pieces around and moving some of the investments around. And we'll talk about that when we talk about some strategies for concentrated equities as an example.
Great.
So I don't know if we want to add.
Yeah, I also think so. We're literally saving tax dollars for the client, and that's a very real number that you can quantify, right? That's a number. We'll run projections, like Steve said, and we can say, if you do this, this is your approximate savings on the estate tax side. But I think there's a whole other intangible or soft value that we're providing, in that we are helping clients achieve their goals in terms of where they want their assets to go, either during their lifetime or at their death. And we are helping them kind of conceptualize and bring to light what they want for their family, what they want for their family goals, and making sure that happens. And I think there's a lot of peace of mind in knowing that that's in place for the clients, that they're happy with the plans, because, as Steve often says, if you don't plan, the state has plans for you, right? The state has laws that tell you where your assets go if you don't tell them. So we help create a plan, with the client's goals in mind, that carries out their wishes as they want to be carried out. And there's a lot of value in that, that for the client, maybe not dollar wise, but happiness, peace of mind, making sure that their family is taken care of. And I think clients really value that as well.
Absolutely. Ariel, if you would talk to me a little bit about the roles of attorneys and advisors in estate planning. I imagine we have a lot of advisors on the call today with varied levels of experience with estate planning. I imagine some have quite a bit, and some maybe are used to sort of more transactional, just handing estate planning off to an attorney, right? Can you talk a little bit about the different roles and what financial advisors can really bring to estate planning that maybe attorneys aren't right now?
Yeah, definitely. So I think that financial advisors are in a unique position that attorneys, by their very nature of how the law firm is structured and by their role, can't be in. And what I mean by that is attorneys and law firms, the way that most of the industry is structured today, is that attorneys bill by the hour, which means that they are often waiting for the client to come to them with information, life events, news, before they can take action, right? And that's maybe too late sometimes, or at least, too close in timing to an event that it cuts into the effect of estate planning, because attorneys can't really call up their clients every month and say, has there been a birth, a death, a wedding? How's your business doing? How's the stock doing? Because the client doesn't want to get a bill for a check-in, right? So the industry takes an approach where, and certainly there are exceptions, right? Some attorneys have regular meetings with clients, but for the most part, you end up with a very reactive profession. Certainly there are attorneys that are proactive and they're creative and great attorneys, but just as a matter of how the industry is structured, you have a very reactive approach. The financial advisors are in an amazing position because they tend to have deep ongoing relationships with their clients, with the added benefit of seeing a dynamic balance sheet or personal financial statement that they know when the client is considering selling their business, or they tend to be, one of the first calls, hey, I have a new grandkid. I'd like to set up a 529 plan or whatever it is. So they're in a unique position to learn information in a timely manner. And where the financial advisor, in my view, can add value is they don't have to be, it's great if they become experts in estate planning, happy to to talk to anyone about that. And the more they know, I'm sure the more a value add. But actually, at a minimum, I think the biggest value add is recognizing those moments in time where the client should be considering estate planning or doing something, in advance. So if the client is about to sell a business and they know a year before, that's the perfect time for the financial advisor to say, I don't exactly know what that plan is, but this is the perfect time to bring in your estate lawyer. Let's check out the options and recommendations and figure out what makes sense for you. Or you're about to get married. Hey, do you have a prenup? Let's bring in your lawyer and think about it, 6 months before the wedding, not the week before the wedding when the client's, the individual says, hey, teeny lawyer, I'm going to get married next week. Do you think I need a prenup? So the financial advisor is in the best position to just, the very minimum, say, this is the right time to bring in a good team. And they're in the position to help the client find the right team at that time.
Great. That's helpful. Let's jump into the actual playbook. I'm going to pull up the cover here, but as I do, Steve, would you talk a little bit about the sort of inception of the playbook, where it came from, and how it came to be?
The playbook really came out of, I'd say, my frustration that even inside of our own firm, there were things that weren't being done for clients. And I'd say not just for estate planning, for everything, but as we talk about estate planning, there's a lot of things that need to happen. I'll give you something that's simple. A client's child turns 18 years old and is going off to college. If you don't have a healthcare and financial proxy and a HIPAA release, there's a chance that if the child's injured, they overdo it at a fraternity party, end up in the hospital, or they play sports and they're injured in sports, there's a chance the hospital is not going to share information with you. And so having those documents done in advance so that if there is an unfortunate event, the parent can take over for the client is a simple example. Well, even in our own shop, it wasn't getting done. I even missed that for some clients because it just wasn't in front of me in terms of things that we should be doing day to day. So the playbook was a checklist of sorts for everything that we should do for every client periodically, most of them at least once a year. And in the estate planning realm, it's things like checking on the ages of the clients and children, and do they need these documents? It's things like reviewing their fiduciaries with them periodically, reviewing their letter of wishes, making sure their documents are up to date. All the transactions that need to happen are happening when they're supposed to happen. And one of the things Ariel didn't touch on was many attorneys might put a transaction in place for a client, but they don't pay attention to it afterwards. They leave it to the client to administrate the transaction. We don't. We administrate the transaction. Or if they do a GRAT, we'll talk about GRATs, I'm sure, later. The attorney may craft the GRAT. They may transfer the asset in the GRAT. They probably look at it at the end of the term and go, well, how did it work out? When all the way along the term of that GRAT is a asset inside the GRAT rises and falls in value, there's an opportunity to re-grab that asset. And so we'll talk about things like that too. But the playbook's just a list to make sure it gets done. And then as you're on the engaging new clients page here, it also helps folks get into the right conversation with their clients so they're collecting the right information. So back to Ariel's point about most attorneys don't have the opportunity to really collect the information like a balance sheet. Even the attorneys that we think are outstanding that we work with on a regular basis might say, well, I didn't know what their balance sheet looked like until you showed it to me. And now we can make other decisions that we might not have made earlier. Advisors have an opportunity to have a very, very intimate relationship with their client. If you're involved in estate planning, you know what their net worth is. You generally know how their marriage is. You know what their health is. You know how they feel about money, their relationship is with money. You know about their kids and when their kids might inherit money. You have an opportunity to influence them in a way that nobody else may have an opportunity to influence them by talking about the things that matter to them. And so working that into the conversation is, again, part of what the playbook is there for, is to make sure that those questions are being asked and things don't fall through the cracks.
it sounds a little bit like, sometimes when I've talked to advisors, it's estate planning is very much a sort of a single conversation that's done and then left behind. And it sounds like this playbook is also an effort to just ensure that this is an ongoing conversation, that there are sort of different milestones that you're approaching throughout the year, and that it's not just a one and done conversation. Is that accurate?
It is, and it's funny that probably the most the question I'm asked most often when a new client comes on board, and we charge fixed fees for the work that we do for clients, is, well, I assume after the first year, like, we're done. There's nothing else after that, and the fee stops. I'm like, it's totally up to you. After you pay the first year's fee, you can leave anytime you want. But what really ends up happening is clients start to uncover opportunities that they didn't know existed, or problems that they didn't know existed, or things that we have to, I can't think of the right way to say it, if you will, from prior counsel.
That's a technical term, yeah.
Yes, and that takes time. And so I would say almost every time the engagement either continues, and we have a 3% escalator in there, so it goes up a little bit every year in terms of fees, but it often increases in scope because there's extra work to do, or because we get involved with their adult children and their relationship with money.
Well, since you're talking about fees, actually, I do want to kind of move into the playbook itself, but let's talk
Yeah.
about fees, because I think, clearly there are different fee structures at different firms. How does Advice Period approach this? And then also, you know, how can like, if you could take a step back and talk about how like an AUM model might structure it versus a fee model, and just kind of give people a kind of some different approaches that you might.
Yeah, and this is a good opportunity for some anecdotes with real client stuff. But and ironically, this whole fee topic really was the genesis of Vanilla, which was years ago when we moved to a fixed fee arrangement, and we were starting to focus on estate planning. If a client, I'll just again use 100 million to keep it simple, but it doesn't matter what the numbers are. If we moved $30 million out of someone's estate, but still showed them their investment report, it still showed 100 million. It, maybe the titles on the account names were different, but the client just saw the bottom line number and they're like, what did we do again last year? And what am I paying you?
Right.
And so we developed in Excel a very nice report that would show some things different than clients typically get in a performance report. And that was asset classes by the way clients think of them. What's my investment real estate versus my personal real estate? What are my vested versus unvested options? What's in liquid securities versus cash or illiquid assets? And that's the vernacular that most clients use, where I'd argue that most advisors show up with unnecessary complexity. Well, you've got micro cap here and ultra small cap, and they're different in this way. And here's large cap value, international, and the clients basically will pay extra not to have to go to those meetings because it's just confusing. Ultimately, they just like, I want to leave. And so we made that simple. The next big block was how much is liquid versus illiquid. And the next two blocks were all about estate planning. What's in your estate versus out of your estate, and what's the tax savings by the assets that are out of your estate. And then we just projected the growth of their estate in and out, and the taxes out to age 95 at 5%. And very quickly, the conversations went to, whoa, that number's huge. Why aren't we doing more of that? And it very, very quickly went away from the investments into the estate planning. And the reason I say it was the genesis of Vanilla is we do those manually, or we were doing those manually, and we wanted to automate them, and we hired some folks to help automate it. And then ultimately I showed it to other people in the industry, and they're like, I want that. And that effectively became Vanilla. But going back to what I said earlier about how people charge, the significant majority of the industry charges based on AUM. And so you ask different questions because you have a different driver. If I get paid based on assets under management, I care about one thing generally: get more assets under management. And if it's investment focused, I'm going to focus on the investments. So true example, client says, I don't think my returns are really that high. I've got a conservative portfolio. I want to take some money out of my portfolio and pay off my $9 million mortgage. The advisor says, no, 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 don't do that. I can get you a really good loan from our bank, our institution. By the way, I get paid on that. And if you keep your assets with me, I get paid on that too. So instead of paying off your mortgage, which might be the better decision and also lead to some good estate planning, the advisor is motivated to sell them something that they may not need, example, a loan, or keep out a mortgage that they don't need. And then we see this over and over and over. Then if you take an example of a client who might have 5 million liquid and $100 million net worth, the advisor whose AUM focus is focused on that 5 million. I want to see the statements. I want to show how I can add more value and get more AUM because I don't get paid on the other $95 million. We, on the other hand, could care less where the money is. We're happy to invest it. We think we do a good job. We try to make it really simple for the client. And because our fees are very much driven by the services that we provide and the value that come through those services, it's heavily weighted towards planning and very heavily weighted towards estate planning. So to add the investment piece on for us is very small, which also makes us somewhat indifferent to it. And so the question that I ask may be very different than the question an advisor that's AUM focused. I want to see copies of all your trusts, and I want to see a personal financial statement, or at least we'll map one out together. Whereas an AUM advisor may say, I want to see your investment statements because I just care about getting that money. And so different drivers cause different reactions.
So it sounds, I mean, it's clear that you're a proponent of the fee-based model.
Is it obvious?
I will. No, and that's fair, right? Like it's a really interesting and vibrant discussion in the community, I would say. I would also point out though that we've talked to advisors on the AUM model, great responsible advisors who also embrace vanilla as a way to really showcase the worth of why they're getting that fee, and they care deeply for their clients. They work on an AUM model because that's best for them, but they understand that there's pressure to show the value of that fee. And so vanilla has become a huge differentiator for them in that respect. So I think that I just want folks to know that it can work for both fee models for sure, even though.
We'll say it this way. There are good advisors on each side of that argument and every other argument. It doesn't matter where they work. There are good advisors everywhere. And there are bad advisors on both sides of that. So there is no one-stop answer for everything. I think my argument is more around doing a great job for clients in a very holistic manner. And if the technology can help that, if the playbook helps them do things they might not otherwise have done, or if the technology that we're building in the vanilla can help the advisor be a better advisor and do those things, it doesn't matter how they get paid. I really care in terms of consumers that they just have a great experience and somebody is addressing all the needs that they have.
Fair. Okay, so in the interest of time, I want to move us to the actual playbook. We're getting some great questions. Folks out there watching, please do continue to add those in. We're going to definitely have time at the end to answer some of these questions, but I want to make sure that we talk through some of the actual strategies that Steve and Ariel and company use when they're talking to clients. Why don't we start with the new client conversation? What are those big questions you ask? What are the things you're looking for when you're bringing on and onboarding a new client? Maybe Steve, if you can talk about some of those big questions, and Ariel, maybe talk about what are some of the things you're looking for in the documents and things of that nature.
Yeah, all of my conversations start with the things I just mentioned, which is I want to see the practical pieces of it. I want to see the balance sheet, and because I want to not only understand their total net worth, but what kinds of assets they have in there. We'll find out, are they a Section 16 person, or do they have concentrated assets, or are they a fund manager where they have carried interest? And all the reason I'm asking these things is because it helps to prescribe what solutions make the most sense if we are going to engage in some estate planning. We want to see their documents, and I'll save that for Ariel to talk about what we look for in the documents. Sadly, more than 3/4 of the documents we see or the clients who come in need more work done, or they need their documents redone. And that's a sad truth about the legal industry, is there is no one way of doing things. Like, you go to across the board on asset allocation, and most people are using a similar type model to run their asset allocation analysis. You'll see similar things across legal, but the documents vary from firm to firm, even lawyer to lawyer inside of firms, and it makes it very difficult to find uniformity. And so again, Ariel can talk about that. Only after I've seen those things do I want to know, how do you feel about money? What is it here for? Where do you want it to go at the end? There's only one of three places your money's going. It's going to heirs that you name, which is often family members. It can go to charity, or it can go to the government. And we spend our time reducing the last one so it can go to the first two. And understanding those things will start driving other questions. So I'll stop there and we can hit others as appropriate, but maybe Ariel will spend a minute on things that we look for in documents that we often have to clean up.
Yeah.
Just let me just pause 1 second to tell people what they're seeing on the screen. I'm going to take it down, but Steve mentioned the balance sheet and looking at assets. So I pulled up. This is an image of vanilla, and so this is one of the things that our technology does, is really kind of collect all of that information in one place in a way that's sort of very easy to grok, if you will. But sorry to interrupt, Ariel. Go right ahead.
So I'd say we ask the client to send over two kind of sets of documents. The first being what we call core documents, which is a will, a last will and testament, and or a revocable trust if the client has it, a power of attorney, and a healthcare proxy and or a living will if the client lives in a state where you do it separately. And that's one set. The second set is if the client has set up any irrevocable trusts, like a typically a grantor trust, or a trust for descendants, or a trust to hold life insurance. For the first set of documents, most clients have some level of core planning in place. We definitely see clients that don't, and our first stop is to a lawyer to get those put into place if they don't. But often clients have them in place. But what we tend to see is that those documents are really old. They tend to have done it when maybe they had a child, many, many years ago, and they thought, okay, it's in place, and they haven't revisited it. And when I see that, the first thing I'll look for is, hey, these are Florida documents. Do you live in Florida still? And maybe they do, and maybe they don't. So I'll look to see if it makes sense for where they currently live, because you want to have documents that reflect your state of residence. And you'd be shocked at how many times we see documents that are, two state moves ago. And then I'll take a look at what the documents say. And what I'll focus on are who the clients have appointed as the fiduciaries, and that is either the executor or personal representative, the person who would handle or administer the estate, and the people named as trustees in the revocable trust. And very often the client is surprised, oh, well, that person has turned 95 last week. I don't think that that's the appropriate person in my revocable trust or will. And or the documents will say, everything goes to my spouse, and then if my spouse is not alive, then everything goes to my kids outright. And when the clients, when the individuals did the documents, they had $1 million in their bank account. When we're looking at them, the client has $100 million in their bank account, and all of a sudden their kids are getting $100 million outright, and the clients are, wait a minute. I don't want my kids to have $100 million. Actually, I wanted this charity to have some, or I want my kids to have access to it for education or their health, but certainly not the ability to go in and grab $100 million. So those are the things I'll look for, whether, how it's structured, the state of residence, who are named as fiduciaries. And this is relatively easy to focus on and quickly change if the client needs, because it's revocable or totally changeable at any point, and you can quickly update those as needed for the client. What's also interesting is clients will send over their irrevocable documents, a second sleeve of documents. And in those cases, I think there are a lot of questions to ask. First, we'll want to know what's in them. What do they hold? And then we'll want to see, while we like complexity and we like, sophisticated planning, we don't like complications for no reason. So I'll look, are these two trusts, are they duplicative? Are you paying an accountant to file two different tax returns for two trusts that could be consolidated? I'll look to see whether they still make sense for the client, and I'll look to try to simplify their life if I can. So that's one thing I'll look at if there's superfluous entities out there. The other thing I'll look at, and I find this all the time, is that often these trusts say the same thing as the revocable trust says, and that once it gets to a certain point, it goes outright to children or grandkids. And maybe that made sense 10, 15 years ago. But it might not make sense anymore given what's happened in the trust. So we see this all the time. Trusts balloon, just like their revocable, their individual assets, and it no longer makes sense for these assets to go outright. And the reason is not just because the client might not want their kids to have access to the access to the trust assets, but while assets are in trust, they're protected from the creditors of the beneficiaries. They may even be protected from estate tax if they can be held in trust for a longer period of time. There's all these benefits to the trust. So when we talk to the client and say, did you really want this to go outright? Did you know that there are all these benefits? They say, oh no, I meant for them to be held in trust for a long, long time. And so we'll look to see whether there's any way to mitigate that. I'll also always look at the fiduciaries, the trustees, see if they make sense, and see if we need to make any tweaks to those trusts. So that's what I'll focus on when I do my review.
I think you
wonderful.
hit on some of the bozo no-nos, sticking with my clown theme. The mandatory distribution, particularly from GST exempt trusts, are things that just are red flags for us that we typically are trying to fix for clients. And we often have, which is probably a whole different webinar, discussions about prescriptive planning versus what we call a family bank and the impact that it has for large estates down the road. But I can think of two examples in the last year, one last week where we're with a very large prospective client, and the client described exactly what we wanted. And we said, yep, that's what we understand what you want. That is not what your documents say. And I can think of another client, also a very significant wealth, that the documents were written in a way that if you didn't really go through them in a precise way and run the math, you wouldn't realize that nothing would be left over for charity. And they were very, very charitably inclined. But because the documents kind of specified where money went and when it went, and it was a calculation of what was left over for charity, the exact opposite of what they wanted to happen is what happened. And so going through and really modeling out, which again, this not to put in too big a plug for vanilla, that's kind of what vanilla does. So someone can visually understand what's going on with their dollar, see what the beneficiaries are getting, and then make a decision around whether or not they want to make a change.
That's great. So we've been talking a lot about ultra high net worth clients, and I know that that's your typical client has a taxable estate. Steve here had a question. I think it's a great one. Can you talk a little bit about applying the playbook, and specifically, we're talking new client conversations here, to clients that are under 5 million or don't have taxable estates and may not have taxable estates?
Yep. So I already touched on, adult children. And it doesn't matter what your net worth is, you should have these documents for adult children. Every client should have their core documents, and Ariel said what I often say when they're like, we haven't signed them because we can't agree on who should be the guardian for our minor child. And as I say, no problem. The state has a plan. They'll put them probably into an orphanage, and don't worry about it. You don't need to do your documents. So that'll get them off their ass pretty quickly to get their documents signed, even though that isn't factually what happens. But having their core documents in place spares the family from having to deal with more complexity in a very difficult time. And in many states, if you die intestate without a will and you're not married, and you have children, or you have parents, or you have siblings, the money gets divided up. And so if you wanted it to go totally to your kids, or you wanted some of it to go to your parents who are ailing and you're taking care of them, those things don't happen the way you want if it has to go through probate and you die intestate. So I'd argue everybody who has a family or who has any money which is pretty much every advisor's clients, is one or both of those, should have their core documents in place. And so that's how estate planning matters for them, and being able to visualize it, because people's estates grow, helps them think in advance. And then you can include the attorney into the discussion. You can include the insurance agent if the advisor is not the insurance agent in the discussion, and share all the information that is now kind of living, breathing in the software.
That's great. Yeah, and to further that, to the question, the playbook itself is still very applicable if you don't have ultra high net worth clients. It's just, you're going to still be looking at those same core documents. You're still going to need those same core documents, that, like the advanced healthcare directive that Steve brought up. There are just a few of the elements will be a little bit simpler, and you won't necessarily need them. So, but the core of it remains. So I think that it's still a great resource for you if you're not looking at an ultra high net worth client. Do Ariel and Steve, do you have anything you'd like to add to new client conversation topic before we move on to talk a little bit about maintenance?
I think we go on ad nauseum about the things that
Yeah.
are important. So it's if you engage in the conversation, things will come out of it that need to be followed up on. And I guess without trying to drum up a whole bunch of what examples of what those might be, I think, at least again, for our advisors and the folks I know that are disciplined, and the playbook helps them become disciplined about this, things come up that they don't know about, or we're not aware of, or that are important to them. Someone in their family may have had cancer, or died, or died from suicide, and all of a sudden those things are important to them, and they want to find out how to incorporate it into their overall plan. And if you're not engaging in that conversation, and the client's not bringing it up, you're missing an opportunity to connect with the client and to help them fulfill their wishes. So I'd say the underlying thing is just have the conversation, check the simple things that need to be checked. It's not difficult. You don't have to be an estate planning expert. You just have to be diligent about following up.
Well, there's an intergenerational component to this as well, isn't there? I mean, I often hear about the challenges that advisors have in reaching the next generation, and estate planning seems like a really valuable tool to do that.
Yeah, again, at least for me, as I'm working with clients, again, we focus on clients of pretty significant wealth, but knowing that their kids are going to inherit wealth, they want them educated in the process. So part of the discussion is, what do we tell them? When do we tell them? Oh, by the way, we gave them a lot of money a while ago, or we put them in a deal and that did very well. They need their own documents. Or there's even good planning from old documents where we might make a distribution to G2 and have them use their exemption. So, most everyone should know that the exemption is going to go down by, almost half, if not more, in 2026. And for clients of significant wealth, it makes sense to use that exemption. And even for their kids, if they're the beneficiaries of an existing non-grantor trust, it often makes sense to distribute assets out, have them plan with it, and then they can pay the taxes on that new GST exempt grantor trust by taking distributions from the non-grantor trust. And while that, for those who aren't familiar, may sound like a lot and really complicated, it's actually really simple. But the math around the impact is gargantuan, particularly if you're going from a non-skip trust to a skip trust. So little things have big outcomes.
Excellent.
Yeah.
Okay, we've talked. Oh, please.
I would just add that Steve's talking a lot about, at the end about these trusts, and maybe that is more applicable to the more ultra high net worth clients. But I think across the board, I'd say for me, the key is to ask a client about themselves and their family, which is obvious, maybe obvious, but I find that some of these things that they tell you, or maybe not others, for example, some clients will say, if you ask them about their children, maybe one has special needs, for example, and that's not estate planning per se, but that might be factored into, let's get us, going back to trust for a second, a special trust in place so that that special, that child with special needs is very protected and maybe can continue to take government benefits without having your wealth affect the child's ability to benefit. So I think just learning about the client, which applies to every client across the board, what's important to them, what charities, what's important to their family will help lead whatever estate planning needs to be done.
Wonderful. Great. let's move on and talk a little bit about once we've established the client, once we've had those initial conversations. You know, a lot of advisors today sort of leave it at that. But I think one of the things you've talked about is the ongoing conversations that need to happen. So let's kind of talk about what needs to happen on a yearly, maybe not everything happens on a yearly, but on an ongoing basis. Sorry, I'm trying to get in full screen mode there. On an ongoing basis with these clients. So we've broken it up into sort of first half of the year and second half of the year. I know that, you know, different firms have different ways of approaching this, but Steve and Ariel, can you talk about how you look at this at advice period and what these conversations need to entail?
Yeah, I think for the basics, and you've got core document review on there, it's just making sure every few years there's a pretty healthy review. Our typical structure for irrevocable documents is to have one that's very flexible. It's discretionary, and there's a precatory or advisory letter that goes with it that we help the client craft and think about things they may not have otherwise thought about. And so reviewing that, what we call letter of wishes, annually is something that's important, and people change their mind all the time based on family circumstances that change, their kids are behaving or not behaving, or in terms of being responsible, or they have a different view about money as they age. So that's something that we do often. Using their annual exclusion, you've got on there as well. That tying into 529 if it needs to, or do we want to make crummy gifts for a life insurance policy to fund that, or even discounted gifts of other assets, or forgiveness of notes. So things that should be handled annually include all those. And then there's all the administration of plans that we've done. So if we did a sale to a defective grantor trust, or we employed grats, those should be done at least annually. And if you're doing planning with those kinds of vehicles, you always want to not just annually, but constantly look at the changing circumstances of the assets in those trusts, because most trusts have the ability to swap assets out. So you can take one that's underperforming and swap in one that you think might perform, or you can take an asset, if you've done a grat, which is kind of heads you tie and tails you win, and it's inside of the term of 2 years. Let's say if we've done a 2-year grat has spiked in value, we may want to swap that out and do a new grat. And so that's something that is not just annual, but ongoing. And again, we talked about it earlier. Lawyers generally don't have the optics, the eyes on these things, and can't weigh in the way an advisor can. So those are all ongoing things that we do for clients. And I don't know, Errol, anything I missed there?
I think you got it.
Well, you mentioned letters of wishes, and I suspect that not everybody is using those to the extent that you're using those. I'm not sure, but I was wondering, Ariel, maybe you could touch on what letters of wishes are and sort of the benefit and challenges of those.
Yeah, sure. And I agree with you. In my years of practice, they were seldom used. And so for the audience who are not familiar with a letter of wishes is literally a letter written by the settlor or grantor of an irrevocable trust, or a grantor, just actually of any trust that's created during life or at death, that provides guidance to the trustees as to how they'd like, what the intent of the individual is with respect to how to administer and distribute assets of the trust when the settlor or grantor is no longer living. It's not binding. It's not a binding document. It's not legally binding, I would say, but it helps shape how the trustee thinks about administering the trust and distributing assets when the grantor or settlor is not around to consult with. And I'd say they're actually increasing in popularity. During my career as a lawyer, they were not super common, but they're increasing in popularity. And the reason that they are, in my view, is because a lot of trusts, and actually how we recommend that trusts be structured these days, is that they're structured to be very flexible. And what that means is that we often recommend that a trust often, not always, but often recommend that trust be what we call a discretionary trust, meaning that the trustee has full discretion to make distributions, and there are no required distributions from the trust. And we feel that, generally speaking, that provides the most amount of creditor protection and asset protection and estate tax protection for the beneficiaries of the trust. But with that flexibility becomes a lot of latitude for the trustee to make those decisions. And the letter of wishes helps to guide that trustee, because it's a big job, right? You can make distributions for any reason to the beneficiaries. Well, the trustee will say, well, what did you want me to do? And so that letter helps provide the intent and shape the intent for the trustees, and helps them guide them when during the settlor's life. The trustee can just call the settlor and say, did you want your kids to have, 500,000 for this? And the settlor say, well, that wasn't really my intent. But once the settler is no longer living, this provides a stand-in for that advice. And so we love letter of wishes because being a trustee is a big job. And this helps to provide that structure, that show that intent, but also because it's changeable at any time. The client can revisit what their intent is every year, change their letter. They can change it every week for they want, but it allows you the flexible structure, but also at the same time, the guidance to the trustee. So the trustee has, something to refer to if they needed to in the future. And the client loves it because it allows them to rethink their structure every year. Well, actually, it wasn't important to me that my kid have capital to start a new business, but actually I see that it's really important to my child. So I want to let the trustee know that my intent is that the beneficiary should have access to funds to start a new business, or to, buy a car or buy a house. And so this provides that. And we help the clients, draft these letters, and also remind them that they have them outstanding each year, and say, hey, does this still meet your wishes? If not, let's go back and redraft this so it does. And so it's very clear what your intent is, should you not be around to tell the trustee.
That's great. A really nice summary of that. A question from David here about letter of wishes. It says, I've run across attorneys that do not like letters of wishes. Is there a reason behind this that you've come across? If there's nothing to discuss, you can ignore. But is there?
Well, go ahead.
I haven't come across a reason to dislike them, other than the fact that they're not binding, and some attorneys maybe prefer, if there are specific wishes, to put them into the trust agreement so they are binding. But we find that the more specificity the client puts into their trust, generally tends to be problematic over time, because clients' needs change, family needs change. And so we often find that while the client was very gung-ho on this particular thing being in the trust 10 years ago, it no longer meets their goals. So, which is why we tend to veer towards the discretionary trust, in which case I find that lawyers are fans in those cases. I'll let Steve add to that.
Errol hit the nail on the head. I think there's, like anything, you're going to have a subset of people that have very strong feelings one way or the other. But I would tell you, working with a lot of the top attorneys across the country, most of them are comfortable with it because it provides guidance, but still provides all the protections that are in there. Being a trustee is a tough job. I mean, it's actually a horrible job. There generally is no compensation, or not enough to warrant the risk that they're taking. And so having guidance alleviates them from some of that risk. And so we think it's important, and those attorneys who don't are certainly entitled to their opinion.
Great. I'm going to field a few more of these questions. We've got some great ones here and only a few more minutes left. This is a nice one about how financial advisors position themselves. So if you start with estate planning and then move to other topics over time, how do you define yourself to a potential client, financial advisor, financial planner, et cetera? If you could speak to just just positioning in general, and how you a financial advisor might position themselves with estate planning as a part of, that'd be great.
I can just tell you when people say, what do you do? Which is a question I hate. But if someone comes to say, what do you do? I say, I'm in the wealth advisory business. And that really covers everything, because their wealth is their financial wealth, both liquid and illiquid. It includes investments, it includes estate planning. It includes even the emotional and familial wealth that they have with their kids. Because we, again, haven't spent time, and it's probably beyond the scope of this call, talking about all the interpersonal stuff and the things that we talk to clients about with respect to their relationship with money, and what we've observed over 30 plus years in how money is a magnifying glass, and if things are bad, it makes them way worse. And if things are good, it can make them way better. But more often than not, money is weaponized and unintentionally. And trying to help families to protect against that is something we spend a lot of time doing.
Here's a question that's about vanilla that I wouldn't feel comfortable answering, but Steve, you're the guy, so you can decide how you want to answer it. When are you bringing back your core and essential documents to your offerings? Is that something that's on the roadmap?
It is on the roadmap. I will loosely say it should be by the end of Q1, so not too far out, but we'll reserve some flexibility. As we all know, technology can be buggy. So we took our first iteration, learned a ton about the experience and even the documents, and completely reworked it. I can tell you, having seen it, it looks fantastic, including the mailers that go out to the clients and everything. And so let's just say in the next 3 months, I'm comfortable saying that it should be up and ready to go.
Thank you. Appreciate it. So on the roadmap, near term. Okay, so with your estate first approach, how would your typical first meeting / call go with a potential client? How do you come to an agreement to work together, since it's not centered around investment management and opening new accounts and starting management, et cetera? Basically, I think the question is really about how
do you
different.
close a piece of business selling this way?
Yeah, yeah, that's right. That's right. Like, how do those first conversations go, and how do you feel each other out in terms of whether you're going to work together, and how do you close it?
Well, the latter part is, does the client feel comfortable? Do they think they're getting value for what the fee they're paying? And I kind of hit on it earlier, so I won't go through it again, other than to say we highlight that they have a big problem. So focusing on folks with taxable estates, you have a big stinking tax bill. Fact. Here are the numbers. Can't change anything about that. We have a big solution for you, and we will go through specifics if they share some basic information about the size of their estate or what it's made up of. And I think we do our best to demonstrate that we have a high level of knowledge and sophistication, so that they quickly feel confident that we're the right people to solve their problems. It's why we ask for the documents, so we can highlight your attorney missed the boat on this one, or it doesn't say what you want it to say. But I can tell you, like, I just been bringing on someone new who's got $80 million and hasn't used their exemption and hasn't done anything. And I asked this person, did you tell your attorney that you didn't want to use your exemption? You didn't want to do any planning? And they said, no. I said, well, your attorney needs to be fired, because they have an obligation. I mean, to me, it's quasi malpractice, even though it isn't legally malpractice, not to do that. It's like letting the client that smokes and eats donuts all day continue to do that without at least telling them this stuff may be bad for your health. So I think it's just proving that we know what we're doing. You've got a problem, we have a solution, and the cost of it is dramatically less than the benefit.
Great. How does vanilla work from state to state? That's a good question.
Well, in terms of the software, it's somewhat irrelevant. Balance sheet's balance sheet. There is some state specificity with respect to calculations. I actually would argue they probably should be left out, because it creates unnecessary complication. But a bunch of advisors and users have kind of insisted or requested it. But with respect to documents, each document is state specific and is reviewed by local counsel to make sure that it complies with the state requirements.
Nice. What's the most efficient way to make estate planning more important to new clients? Oftentimes that can be the most difficult obstacle in implementing a proper plan.
Make it important to you, and then it will be important to them. They're going to focus on what you talk to them about. They're not sitting there just to be entertained. So if it's what you talk about and you believe it's important, then it's important. If you glance over it or don't read the documents, then they're going to think it's as important as you do.
That's great. This is an excellent question that I love to see. Is the vanilla platform going to be demoed? Unfortunately, we don't have time to demo it in this particular webinar. I do encourage everybody to go to justvanilla.com. You can see a short video on that, and you can there's also a place where you can reach out to sales folks that can walk you through a demo and actually kind of step by step show you all you need to know. We're about at time. I would also like to encourage you to go to our LinkedIn and connect with us there. If you haven't done so, we're sharing tons of great content. We're also doing that on Twitter. We've got a great blog. We're really, we want to become your sort of the place to go for your estate planning knowledge. So please do jump on our website and give us a shout on social. Anything else to add, Ariel and Steve, before we go?
Thank you. This is great.
Oh, yeah, it was enjoyable. Thanks.
Thank you both. Really appreciate it. Thanks all. Talk to you later.